Şimdi konuşmalarını yapmak üzere Avrupa İnsan Hakları Mahkemesi Başkan Vekili Robert Spano'yu sahneye davet ediyorum.
Honorable President Zühtü Arslan, distinguished members of the Turkish Constitutional Court, dear colleagues, dear friends, ladies and gentlemen. It is a great personal honor and a pleasure for me to be with you here today in the historic city of Istanbul on the occasion of the 7th anniversary of the individual application system before the Turkish Constitutional Court. On behalf of my colleagues and friends, Judges Bosniak and Yüksel, who are here with me today, we thank you very much for your invitation. I just realized when I met President Arslan this morning that I have been, through most of my time in the Strasbourg court, dealing with Turkish cases, as some of you know. In some ways, even though this is the first time that I've been to Istanbul, I feel, at least at the professional level, that I have finally come home. Allow me to begin by expressing my sincere gratitude to Constitutional Court President Arslan. His efforts in developing good relations between the Constitutional Court of Turkey and the European Court of Human Rights are highly appreciated. To further these relations, he paid a visit to Strasbourg early this year on 4 March, along with a delegation of justices, including the Vice President, Engin Yildirim, of the Constitutional Court. It was the very first time that the judges of the Strasbourg court examining cases coming from Turkey had direct contact and a constructive dialogue with justices of the Constitutional Court on issues of mutual interest and concern. In his intervention on that occasion, President Arslan emphasized that it was important to maintain and develop effective judicial dialogue between the European Court and the Supreme Courts in Europe. I am in absolute full agreement with President Arslan's views on that issue. It is my strong wish to maintain this dialogue in the future. It is, after all, an essential element for the effectiveness of the convention system that the Strasbourg Court's case law is preserved and enforced by our judicial brothers and sisters at national level. As you are all aware, Turkey is one of the founding members of the Council of Europe and has contributed to the establishment of the human rights protection mechanism under the Convention. I consider it important, firstly, to underline the crucial role played by the national courts in safeguarding fundamental human rights by reason of their direct and continuous contact with the vital forces of their countries. For the situation domestically in Turkey, it is of course of great importance that under Article 90, Paragraph 5 of the Constitution, international human rights agreements like the Convention, duly put into effect, shall prevail in this regard. At the intergovernmental conferences on the reform of the Convention system that have taken place since 2010, the ministers have adopted political declarations that emphasize the national pillar of the Convention system. In particular, the text and spirit of the declarations of Interlaken, Izmir, Brighton, and Brussels, and more recently the Copenhagen Declaration, make it clear that the Convention system for the protection of fundamental rights is now in a new phase in its development. A phase that I have termed myself in extrajudicial writings the age of subsidiarity. The principle of subsidiarity is implicit in the structure of the Convention. Subsidiarity encapsulates a norm of the distribution of labor between the court and the member states with the ultimate aim of securing to every person who finds himself or herself within the jurisdiction of a state the rights and freedoms guaranteed by the Convention. In other words, it is not the Strasbourg Court that is entrusted with the day-to-day responsibility of securing Convention rights. It is the member states. In accordance with Article 1 of the Convention, it is the national authorities which are the primary guarantors of human rights, subject to the supervision of the court. When the member states fulfill their convention role by applying in good faith general principles in the court's case law, the principle of subsidiarity implies that the court may defer to their findings in a particular case. However, and let me be clear on this, subsidiarity is not realistic without strong, independent, and impartial domestic courts embedded within a national system that is governed by the rule of law. It flows from this that member states demonstrate with their actions whether deference is due under the principle of subsidiarity. In particular, and here is a true focus and theme of my message today, the reasoning provided by national courts in their judgments must secure and protect their independence vis-à-vis the executive and legislative branches. In this context, I would like once again to underline the importance of the individual application system before the Turkish Constitutional Court. Following the introduction of the individual application mechanism in Turkey, the European Court rendered its first decision on the availability and accessibility of this new remedy in the case of Hazan Üzün versus Turkey, delivered in 2013. In its decision, the court reiterated that the rule of exhaustion of domestic remedies was an indispensable part of the functioning of the convention mechanism. Having examined the main aspects of the new remedy before the Turkish Constitutional Court, the Strasbourg Court found that the Turkish Parliament had entrusted that court with powers that enabled it to provide, in principle, direct and speedy redress for violations of the rights and freedoms protected by the Convention. It accordingly declared the application inadmissible for non-exhaustion of domestic remedies. The court next examined the effectiveness of that remedy in the context of a complaint raised under Article 5 of the Convention, in particular in the case of Koçintar versus Turkey from 2014. In that case, the court found that an individual application to the Constitutional Court was capable of affording appropriate redress for the applicant's complaint under Article 5. However, you will recall that regrettably the Strasbourg Court's findings and conclusions in the Koçintar case were called into question in the case of Mehmet Hasan Altan versus Turkey, in which we delivered judgment in February 2018. We there had found a violation of Article 5 of the Convention on the basis of the pretrial detention of the applicant. We observed that the reasons given by the Istanbul 26th Assize Court in rejecting the application for Mr. Altan's release following a final and binding judgment delivered by the Supreme Constitutional Judicial Authority could not be regarded as satisfying the requirements of Article 5.1 of the Convention. In our judgment, the court emphasized in particular that for another court to call into question the powers conferred on a constitutional court to give final and binding judgments on individual applications ran counter to the fundamental principles of the rule of law and legal certainty which were inherent in the protection afforded by Article 5 of the Convention and were the cornerstones of the guarantees against arbitrariness. I want to be clear at this point. It still transpires from the current case law of the Strasbourg Court that it continues to place emphasis on the work of the Constitutional Court. It is our national ally. Indeed, since the introduction of this new remedy on 23 September 2012, the Constitutional Court has rendered a significant number of important judgments which have provided a remedy and, where appropriate, reparations to the complainants. It has also played a pivotal role in giving guidance to the lower courts by harmonizing the Convention principles with those of national law. In sum, it is of great importance for the effective protection of human rights and the future development of Turkey as a democratic state governed by the rule of law that the Constitutional Court provides a credible and speedy remedy to justified allegations of violations perpetrated at national level. In this regard, and as I've previously made clear, it is also of vital importance that national courts adopt reasoning in their rulings which, as far as possible, are in conformity with the methodological approach taken in the Strasbourg Court's case law. Mr. President, if I may, I would, before I conclude, make 3 further brief remarks. First, we are fully aware of the difficulties and challenges faced by the Constitutional Court in terms of the volume and sensitivity of cases with which it deals, particularly after the events of 15 July 2016. The European Court also had its share of these difficulties, as we received more than 36,000 applications following the various measures taken under the state of emergency legislation. Although a part of these applications were declared inadmissible for non-exhaustion of domestic remedies, there are still more than 4,000 applications pending before our court on a variety of issues, such as detention of judges, civil servants, journalists, or members of parliament. Second, as you know, 2019 marks the 60th anniversary of the European Court of Human Rights. Throughout this 60-year period, the Court has met the challenges resulting from international and domestic conflicts, migratory flows, and the threat of terrorism. Notwithstanding these difficulties, the Court has contributed to the harmonization of European standards concerning the rights and freedoms of more than 830 million Europeans. Our Court enjoys close and cordial relations with the superior courts of Europe. This interaction has gained a new momentum with the creation of the Superior Court Network, which enables the European Court to strengthen judicial dialogue and closer cooperation with these courts, thereby enhancing shared implementation of the Convention. The Court is proud to have the membership of the Turkish Constitutional Court, the Court of Cassation, and the Council of State. My third and final remark is this. An independent judiciary is the cornerstone of the rule of law and is vital to the functioning of democracy and the observance of human rights. Those men and women that are privileged to be bestowed with judicial power must exercise this power in a manner that is conducive to upholding the rule of law and democratic principles. That endeavor often necessitates a sober mind and a brave heart, in particular in difficult times when our core principles are being challenged. But that is our mission, that is our role. Thank you very much.